name is Goldman, and I'm an attorney with Goldman and Associates. And today I want to talk a little bit about the discovery process in divorces. One key discovery tool is the deposition, the oral statement taken under oath. When we talk about discovery, we talk about the process that the court and the court rules have set up to allow the attorneys to learn about the other person's position in the case. And it could be about a lot of things. You could do discovery as it relates to assets, as it relates to liabilities. You can also do it as it relates to custody. We have always found that it's particularly important to at least consider taking the deposition of the other party in a custody case, because here's what normally happens. You get a custody case, husband comes in, makes all these allegations about, the wife being neglectful of the child or whatever. Wife may come in and she may say, husband does this, husband does that. It's oftentimes a he said, she said. And when you're talking about custody, it's often a he said, she said about the child. Oh, my child is very fearful because of this. My child wants this, my child wants that. It's all somebody saying something to somebody else. Sometimes, depending on the age of the child, you wouldn't want to do this with the child who's too young, but sometimes it's very important to take the sworn statement under oath, to sit in the room and talk to the person who is talked about in the courtroom and find out what they actually have to say. Sometimes people will exaggerate their position. Sometimes their perception is skewed by the feelings that they have toward the other person. They may view something that's not exactly 100% accurate. So sometimes you want to talk about the subject, the individual that is being discussed in the courtroom. And sometimes beyond that, you want to talk to the individual parties. Husband says wife is not a good custodial parent. Let's find out why. We want to find out, the wife says that she's the better choice. Why is she the better choice? What does she know about it? You know what I find a lot? I find that sometimes custody claims are being used to gain position. I'll give you a scenario. For example, there's a high asset divorce. Husband is trying to protect his assets, trying to stave off a claim for a lot of support or alimony. So what does he do? He files a claim for custody. Why? It's the only thing he can really do to get leverage with her, is take the one thing that she wants, custody of the children. So in that scenario, it might be helpful when you're representing the wife to take the deposition of that guy who says he wants custody. Why? Well, you want to find out how legitimate is his custody claim. For example, he says he's the better custodial parent, he's more involved with the children. Great, but you know what you do? You ask that guy, who's the kid's teachers? Who's the kid's favorite teacher? What's the kid's favorite color? When's the time last kid went to the dentist? What's the name of the child's dermatologist? When's the last time he attended a parent-teacher conference? You start asking this, and you start getting a guy who's saying, I don't know, I'm not sure, I think it's this, maybe it's that. You begin to realize that the claim is not born out of someone who's genuinely interested in the child, or else he would know the simplest of answers. You begin to realize that it's a leverage claim. And once it's just being used for leverage, then it's a whole other story. Because you know what's going to happen if it's just leverage? He's going to lose that claim. And there goes the leverage. So all the discovery tools, particularly depositions, can be used in a very appropriate way to really balance out and even the playing field. If you have questions about this, or you have found this helpful, for the questions, of course, reach out to us. And if you found it helpful, please like and share.